jurisdictions, okay, or something to do with traditions, would my Lord know what that case would be and what the issue was? Maybe traditions is the wrong word, but let me give you the case, and then see whether you can give us the determination by the court. And it is the case of Isaiah. And if I go any further, I'll be giving you the answer.
And I seem not to.
All right, then let's just leave it there. But it is on trusts which are overriding rights in land. The court, I want us to stay with the jurisdiction for obvious reasons. That's the primary thing my Lord would be dealing with if you came here. The court has also had occasion to determine quite a number of cases, which I'm sure you, my Lord, may have looked at before you came here, on how its jurisdiction is to be exercised. A matter may involve various aspects, and so the court has had occasion to determine which jurisdiction it will concern itself with when a matter is brought before it. And that jurisdiction is the one where it started with the case from the beginning. The matter, the subject matter must have been the matter for discussion in the superior courts below it. Would my Lord know any cases where that principle has been discussed by the court?
I'm aware about the case of when the court was requested to give an advisory opinion on the issue of whether or not presidential and other elections will take place at the same time. I think the issue was already being litigated before the High Court, and in that particular occasion, the court declined to assume jurisdiction because it determined that that was a justiciable matter which was already before the Superior Court and should come to the Supreme Court through the Court of Appeal.
My Lord, has my Lord read the authority of Toha and Timami in Lamu?
No, I have read many decisions, but not all of them, Madam, the Commissioner.
Yeah, this particular one is the one that shows the character of issues that has transcended the case all the way, and therefore when it reaches the Supreme Court will determine the one issue that has transcended. But that's all right, my Lord. Let's go to something else, and let us deal with the types of judgments. What are the types of judgments that the court can write? The first one is, of course, the usual collective judgment. What are the others?
Collective in being unanimous together, and there's also dissenting judgment, and there's also a separate judgment which concurs with the other judgment.
Yes, there is the majority judgment, there is the dissent.
The dissent and the concurrence.
The concurring, and
yes.
then the individual.
And the individual.
Would my Lord give us the difference between dissent and individual judgment?
An individual judgment is first of all, an individual judgment ordinarily is a judgment which we do in a superior court, where you're not sitting as a college. So that is my own judgment.
No,
as
an
a
individual judgment,
but,
my Lord, in a multiple bench court, in a multiple judge bench.
The individual judgment would be either a dissent, in my view, or a concurring judgment written by a single judge within a panel. I'm not putting. I'm not sure I have the finger on the individual,
okay.
Because I'm aware of the concurring and the dissent by an individual judge within a college of judges.
Dissent must mean something. Concurring must of necessity mean something.
Yes, in concurring, the judge is agreeing basically with the decision, with the final decision, but taking a different route, different reasons. A dissent is disagreeing with the final judgment, giving reasons for that.
Now, this court, and because you mentioned advisory opinions, maybe we can discuss that very briefly. There is the jurisdiction on advisory opinions. Then there is the advice under 260 something, 265 or 7. 265.7, the one given to the president to dissolve. Could you discuss both, my Lord? Similarities, distinctions?
Advisory opinions are sought by way of references to the Supreme Court, and that is done either by the national government or county government or state organ, and specifically seeking a question. You have to come by way of a question which must be answered by a difficult question to be answered by way of guidance to the nation by the court, or to the county by the court. And it should not be an academic question. It should be a question which has a public interest, of a public interest nature. So, there's an issue as to whether that should be done directly, or first of all, one should first of all seek the advice of the Attorney General. So that has been debated by the court, and
it's settled.
Yes,
it is settled.
And their advisory opinion is binding. From the decisions I have seen of the Supreme Court, they have determined that they do not give their advisory opinions in vain. They carry weight, and they are binding on whoever goes to court to seek them. The advisory opinion by the Chief Justice, I thought that to dissolve Parliament, is that what? Yes,
my Lord.
Yes, that one specifically derives from the Constitution with respect to matters which the Constitution had stated should be done within specific time frames, especially legislation. So Parliament was supposed to legislate specific statutes within a given time frames. In this case, the case in point is the one on gender and Article 27.8. And if in that particular case, which the Supreme Court dealt with, there was a majority decision in that advisory opinion on gender, with Chief Justice Mutunga dissenting in that on the timeline within which the statute, the 2/3 gender rule had to be achieved. The Chief Justice then stating that it was to be done immediately in the 2013 elections, and the other judges giving Parliament time up to the 2015 to achieve that. Of course, as we know, that did not happen.
Yes, clearly, my Lord has read that one.
Yes.
The question is whether there are similarities or, differences in the two.
I think they are different because one is by the Chief Justice, basically, that is the realm of the Chief Justice.
It's not the jurisdiction of the court. The Chief Justice is the president of the court.
Yes.
So is it?
That is specific to the Chief Justice to do, not the court as a whole.
All right.
Yeah.
Finally, my Lord, the rules that govern the procedure of doing things in the court, would you mention the ones that you're familiar with in regard to the presidential election petitions, particularly the amendments to those rules, the 2020 amendments to the rules?
I have read the Supreme Court's Procedure Rules 2020, and I have also familiarized myself with the practice notes developed pursuant to the rules 2020. I have, I think if I'm not wrong, also seen specific regulations to do with the presidential elections. Yes. And of course, there has been many amendments to the rules as compared to the earlier rules which we had. But I cannot get into the specifics now.
Which is okay. In any event,
Yes.
when you're on the job, then you are enabled to do it right at that time.
Yes.
I wish you well, my brother.
Thank you. Thank you.
Thank you, Acting CJ. Thank you, Your Honor. I will now request Judge Wasame to ask some questions.
Thank you, Professor. My Lord, you have talked about your experience in Swaziland as a judge, 8 years, the labor court as a presiding judge, and as a judge almost more than 8 years. Is it right to say that you have worked in specialized courts, and the Supreme Court is a court which deals primarily with the election petition, presidential petition? Therefore, as a result of your background, you need a lot of dusting up or catching up or reading a lot for you to fit in the court, because 3 of the judges have been there for 10 years, 2 of the judges have been there for more than 5 years. Any assurance, my lord?
Most of the matters the Supreme Court deals with, Commissioner, and thank you for that, has to do with the interpretation and application of the Constitution. By and large, almost all the matters the Supreme Court deals with. And a superior court deals with the interpretation of the Constitution on a daily basis at our level. And some of those matters we deal with, we always refer to, most of the times, to the decisions of the Supreme Court. And in the process, we become very familiar with the decisions of the Supreme Court, and therefore my practice in a specialized court, my practice as a litigation lawyer, my practice as a prosecutor, my master's in international law, and including litigation. And I said, if you look at the first case in this volume, the first on page number 1, Alivisa, Mary Alivisa, Accord Mondo. It was extensively argued by myself as counsel to the East Africa community in defending our Constitution successively when the promulgation was challenged by Kenyans. So I have a lot of experience in litigation, including doing that before the East African Court of Justice. And this was a landmark case defending the Constitution, which I did successfully together with Kefa from the Attorney General's office, but I led him in the arguments before a 5-judge bench East Africa community to defend the promulgation of the Kenyan Constitution. So I am very familiar with constitutional concepts. And
okay, let's stay with the issue which you had been discussing with the Honorable DCJ about jurisdiction. And you have generally discussed the clear-cut jurisdiction of the court. But there is what I call, from a judge's view or a lawyer's view, the incidental jurisdiction of the court. And in my view, there are 2 instances where the court jurisdiction is not clear from the Constitution, but a person can approach the court.
I think I've come across decisions of the Supreme Court dealing with issues of jurisdiction, whether or not they have jurisdiction to deal with, for example, matters coming on those issues. The case of arbitration, the arbitration case, I think, the new 2 case, I think the issue of jurisdiction of the court to deal with that particular appeal, because the issue, first of all, was whether the Court of Appeal in the first place had jurisdiction to deal with the matter, because matters arbitration should end at the High Court. And I think in that case, the issue of this jurisdiction of the Supreme Court was extensively discussed. And other matters where when we're dealing with the applications to determine whether matter is of general public importance. There's also the issue of jurisdiction to be determined, whether in the certification itself, whether the matter, the Supreme Court can assume jurisdiction to deal with that matter. So it involves interpretation of what is matter of general public importance.
Okay. Article 142 deals with the term of the president, which is the beginning date of when he takes the oath and when the next president is sworn. And 2 says the president shall not hold office for more than 2 terms. There is one instance where the president can hold office for more than 10 years. Do you have any clue? And you have discussed with the DCJ just to guide you?
Yes. Where the president can serve for over 10 years?
Yes.
I think if there is, for example, a calamity and there's a state of emergency, and a country is unable to deal with the general election, I think that kind of a situation might present a difficulty in the transition of one president to another. I'm not sure of any other circumstances, but I think a state of emergency, depending on the nature of the emergency, may lead to a elongation of the term of a president pending an election.
Thank you very much, my lord. Wish you well.
Thank you.
Thank you very much, Judge Wasame. Honorable Judge Majaja, you can go ahead.
Thank you, Chair, and good morning, Judge, once again.
Good morning. Thank you.
Just to continue from where my colleagues have left, I think let's go back to the discussion we had last time, and I referred you to the case, the Camry cases. Did you have a chance to read what the Court of Appeal said and the Supreme Court said?
I actually read the Supreme Court one.
Yes.
After that discussion, I didn't look at the Court of Appeal one, but I got the summary of the Supreme Court of the decision by the Court of Appeal. But there were 2 issues.
Yes.
There was the issue as to the manner, whether or not I had dealt with a specific testimony of from 2 affidavits in arriving at my decision. And there was a question as to whether the petitioners had discharged the honors, how they had proved discrimination, because this was systemic policy discrimination alleged at Cambridge, and I had found in that decision that indeed the petitioners had established a good case of systemic discrimination out of policy, the way the European scientists and Kenyan scientists were treated. That is.
Yes, basically, since you didn't read the Court of Appeal decision, all the Court of Appeal said was you failed to consider the case put forth by Cambridge. That's what and the Supreme Court upheld that decision. So I just want to follow up, not exactly on that, but 2 principles out of that. And I asked you last time, what is the difference? And I believe the Supreme Court dealt the difference between discrimination and differentiation, and why is that difference important in terms of protection of fundamental rights and freedoms?
Discrimination, as defined under our Constitution, is treating persons differently on specific, with regard to specific matters which are specifically outlined under Article 27 of the Constitution. The article also opens up the instances of discrimination in that article are not limited. There could be more, but they are the key ones are race.
So how does that tie to differentiation, and why is that important?
Differentiation specifically is treating people differently with a view to correct past, for example, past discrimination, like affirmative action, which is lawful. So differentiation, in my view, is treating people differently, but within the law, to correct past injustices.
So what is the test used to determine whether an act amounts to discrimination or differentiation?
We have the obvious discrimination, for example.
Yes, we are agreed. We are agreed that discrimination on those prohibited is illegal. But I want us to discuss what is the test for saying this, because differentiation is allowed discrimination, isn't it?
Yes.
So what is the test? What test do we use to say this discrimination is differentiation?
That has to be within the law, either in statute or in the Constitution.
Okay, you've never heard of a rational government purpose or policy purpose? Anyway, let's go to the next one. As a judge of the Supreme Court, you will be dealing with, like in this case, you've made a decision, then it goes to the Court of Appeal, and then it reaches the Supreme Court. Normally, the High Court or the Court of Equal Status is a trier of fact. What is the standard? What is the standard of review of findings of fact by the High Court or Court of Equal Status in the Supreme Court?
A third appeal, generally speaking, is on points of law. If a matter comes from the lower court, from the High Court to Employment and Labor to the Court of Appeal to the Supreme Court, first of all, there has to be some constitutional interpretation or application issue, and the application of law to the facts of the case becomes an issue by the Supreme Court.
So what is the standard, or how does the court treat the finding of facts of the trial court in its determination?
The finding of fact should, unless it is impeached, it's clearly wrong. It's treated as the true reflection of what happened.
Or let's put it another way. When a statute or the court says this appeal is limited to matters of law only, what does that mean in relation to findings of fact?
It's the court deals with conclusions of facts, because conclusions made from facts actually become matters of law. So if those conclusions are wrong from the facts of the case, then becomes matters which the Supreme Court can deal with, because, yeah.
Okay. There is a case of the Supreme Court. I don't know whether you have read it. This is the Wajir governor's petition that reached the Supreme Court. Are you aware of it?
I'm aware of it, but I haven't.
You haven't read it?
I had time to go through it.
Okay, then I'll leave it as that. Then I go back to the same issue of, I'll leave that. I think we have explored it. Let's go to devolution. Devolution is a critical part of the work of the Supreme Court. It's one of what I would call one of the pillars in protecting devolution. Do you agree with me?
Yes, it is.
Without part of the work of the Supreme Court is to protect devolution. Impeachment of governors has become it's one of the modes of accountability within the county government system. Can you tell us one or two principles that have emerged from the cases on governors' impeachment that have reached the Supreme Court? One or two principles, which case?
One of the principles that has emerged from Karaoke Mate case, the Wambora case, is the doctrine of judicial restraint, first of all, so that courts should be slow to interfere with impeachment proceedings, for example, while they are in the Assembly or the Senate, and they should only interfere with the result after the conclusion of those proceedings. So that is one principle. It's also the issue of in fact, in that Karaoke Matter case, I remember there's a long
the second principle?
The second principle is it's a majoritarian principle that as much as possible, courts should be slow to interfere with decisions arising from the vote. Which
is the same as the first principle.
Yes.
So let me move on to the next issue of devolution. Again, revenue sharing is an important principle of county government.
Yes.
Yes. And I'm sure you have read the key decision in revenue matters in county government. Have you read it?
The advisory opinion?
Yes, the advisory opinion. It's the only one, I believe, that deals with the issue of revenue, which is a pillar of the county government. Have you read that decision?
Yes, I've read it.
Okay.
Yeah.
So I'll just ask you two questions arising from that because it's important. What are the two statutes that deal with revenue, that affect revenue for county governments? The two particular statutes that are passed annually.
We have the allocation, the division of revenue bill, and we have the appropriation bill.
Okay.
Yes.
So what did the advisory opinion say about those two bills? And why do you think that finding by the court is critical in supporting devolution?
First of all, there's the issue of which should precede the other. Appropriation should bill should which one should precede? So there should be division. There should be the division of the allocation to the counties first.